Hi guys, I've got some reading. I'm going to read out page 27 of my criminal law book. I want you guys to this criminal law book reading page 27 to matter the burden of proof. I'm going to read it and I want you to point out the two involved in the criminalisation. Number one, the murderer, and then number two, the necessity. Parliamentary. Enough of that. Anyway, page 27. It's Justin Johnson. It's Monday, the 9th of April. So right, I'm going to start from the beginning. Page 27. Here we go. Autorephos acquit and autorephos convict. It may be that the burden of proof lies on the accused to prove that he has been previously acquitted or convicted of a criminal trial. You're listening, make sure you take this in consideration. The two matters concerning the burden of proof. A. Before 1935, it was said that there were the accused that had caused the victim's death. He had to show that he did not have the mens rea for murder. This burden was placed on the prosecution in Wilmington versus DPP 1935, AC 462. I want you to point out the name of the murderer and the name of the accessory. This shows my educational experience that I'm giving you, that I'm taking on board myself. Throughout the web of the English criminal law, one golden thread is always to be seen. This is the duty of the prosecution to prove the prisoner's guilt. The words of Lord Sankey have often been repeated, but they do not explain why the golden thread does not run through insanity and the statutory exceptions. The contrary argument, which is not tied to murder, is that his accused is best placed to explain his conduct. If, for example, the victim is shot dead by a bullet from a smoking gun he held by the accused, who convicted his wife, one might say to put the burden of proof onto the prosecution is absurd. No doubt the triers of fact take a robust views on such facts. This is in the eyes of the judiciary. So imagine you're sitting there as a lawyer. So you've got to point out the murderer and you've got to point out the necessity. Under the influence of DPP versus Smith 1961, AC 290 HL, it was thought that the person intended to do what the natural consequences of his behaviour were. In legal terms, a man was presumed to intend a natural consequences of his behaviour. If this presumption was ever irrefutable, S8 of Criminal Justice Act 1967 abolished it. A court of jury determining whether a person has committed an offence shall not be bound in law to interfere that he intended or foresaw a result of his actions by reason only it's been natural a portable consequence of these actions, but shall decide whether he did intend to foresee the result by reference to all the evidence, drawing such inferences from the evidence as appear properly in the circumstances. Section 8 deals with how to prove intention or foresight. It deals with the law of evidence or procedure. It is not concerned with the substantive criminal law, which is the subject of this book. Therefore, it does not affect the substantive law of murder. This section applies only to the accused intention or foresight. Beyond those states of mind, the common law governs. Section 8 is stated to apply to intention and foresight of results, but the same rules apply at common law and circumstances. DPP versus Morgan 1976 AC 182. If it does not apply where the accused does not have to intend to foresee a consequence in manslaughter by gross negligence, the accused. So Lord Sankey is trying to find out who was the accused of the murder and who was this necessity. But did anyone understand which is which? Doesn't actually state just yet, so we're going to read the next page. It is guilty whether or not he realised that death might result. The same is true of the crimes of negligence. As a result of a judicial construction, S8 does not apply where the accused was intoxicated. The section refers to the jury taking into account all the evidence. The House of Lords in DPP versus Majorski 1977 AC 433 determined that all the evidence meant all legally relevant evidence. Since intoxication is no defence to so-called basic intent offences, it is not part of the evidence with regard to the offences. The Law Commission's draft code CL 13 provides, unless provided, a burden of proving very element of an offence. Any other the fact alleged or relied on by prosecution is on the prosecution. Where evidence is given, where the defendant or the prosecution of a defendant or any other fact alleged on or rely on the redundant of the burden is on the prosecution, or any fact alleged or relied on by the prosecution or any fact alleged relied on or to prove that element of defence or such other fact did not exist. Evidence is given on the defence or any other fact alleged or relied on by the defendant when there is such evidence as might lead to the court or jury to conclude there is a reasonable possibility the element of the defence or such other fact exists. So we're going to report in a minute to find out what's going on. It is saving a free pre-code offences, in which case 101 Magistrate Courts Act 1980 or any corresponding rules of interpretation applying on trial of the indictment, i.e. Hunt continues to apply. The standard of proof is otherwise provided beyond reasonable doubt in the prosecution bears a legal burden on all the balance of probabilities if accused bears it, CL 13.4, except if a difference is wholly or partly based on showing that someone else was guilty, in which evidence of the burden of proof is beyond responsible doubt. Who else was guilty? Who gave him the gun? Where did he buy the gun from? Was he set up? Was it part of a gang hitman list kind of thing? You've got to look at all the different areas. Section 8 of the Criminal Justice Act 1970 is preserved and reformulated in CL 14. A court or jury in determining whether a person had a particular state of mind shall have regard to all the evidence, including where appropriate the presence or absence of reasonable grounds for having a state of mind. Find out their mobile phone always links to going back to whatever their network is and going into the phone company, getting the backlog of phone calls, maybe find out where the alleged gun was bought from, find if it's gang related, furthermore, things like that, because it could be other necessities there to set the situation of the murder up. Also, it could be a thing. It could be a thing where he was led. What's the word? Well, he might have been bullied by the victim of murder. He might have threatened his family. So then, furthermore, he could get less sentence if he was bullied and he was revoked. It could be a less sentence, a life threatening towards his family. They had to go and buy a gun. So they have to look at all different angles to make sure they go down the right channel of prosecution. The draft code therefore refrains the presumption of innocence laid down in Wellington vs DPP above and widens S8 and 1967 Act to cover all code states of mind. Section 12 of Sexual Offences Amendment Act 1972 and another serious sexual offences. Also, that guy they went and killed could have touched his daughter in a playground. You don't know the ins and outs. You don't know what went on. So furthermore, you have to look at all the different angles down the channels. That's why we have to get more evidence, find out what happened, and then we take the legal procedures and act upon it. So you need a good eye for detail, and you need good in-depth intelligence. All the way, I haven't written all these notes down. I don't need to. It's just you have to things you have to think about. Be wary of which states that a jury may take into account the reasonableness of the mistake is deciding whether the accused honestly made a mistake falls within CL. The draft code also retains the present standards of proof beyond responsible doubt when the burden of the prosecution of the balance probabilities when it is accused. Also, doing a spider web, maybe they got a gun because he might have been a painter decorator, he might have been a builder, he might have done £30,000 worth of work, and then the guy that's working for knocked him. So therefore, they've written the spidergram, things that are getting them down, why they had to go into these procedures to actually go and then potentially go and get the gun and go and kill someone. So all these little things could lead to, like I said, what's that word? Can't think the word I was thinking of now. The Draft Criminal Code Law Revision Committee was the first body to take on reform during the revoked. If you get revoked for something like that, stealing is a big thing. So 30 grand's worth of money is a lot of money. Very upsetting. Doing sterling work on the first Theft Act 1968, but is now in more bound in the last met over a decade ago. Law Commission has promoted several major reforms over the last 30 years, such as Criminal Damage Act 1971, in approach to summarising report number 228, Conspiracy to Defraud 1944, power 1.18. I'm going to leave that there, guys. I'm going out, but I'm going to sing you a song. I'll put my mic on, but Trace is asleep, so it'll be a little bit quiet. You hold your side, you know they for my handle. This kind God, mighty God, we know you're fit to see your finish, so Hosanna, J over this kind God, mighty God, we know you're fit to see you finish, oh Hosanna, J over this kind God, mighty God. I'm going to say I'll try and hit some highlights, but obviously when people sleep, we'll be careful. I'm pressing on the upward way, new heights I'm gaining every day, still praying as I'm onward bound. Lord, plant my feet on higher ground. Lord, lift me up and let me stand by faith on heaven's tableland, a higher plane than I have found. Lord, plant my feet on higher ground. My heart has no desire to stay where doubts arise and fears dismay. Though some may dwell where those abound, my prayer, my aim is higher ground. I want to live above the world, though Satan darts at me a hurl. I'm going to go now, guys. I'm going to go down and hit the high notes because I've also got people resting. Speak soon.